Good evening, friends. Welcome to the YouTube channel Advocate Amit Kumar Gupta. In my series on the income tax cases, the case which I am going to discuss today is DINESH VAZIRANI versus Principal Commissioner of Income Tax. This case has been decided by Bombay High Court. This is one of the best judgments which the Bombay High Court, Honorable Bombay High Court has given in the recent 2 and 3 years. And this case has been reported in 445 ITR at page number 110. This case has been decided on 8th April 2022. The facts of the case are very interesting, and the decision of this case strengthens the trust of the assessee on the courts. In this particular case, the assessee sold some shares, the assessee received some consideration, and some consideration was deposited by the purchaser of the shares into some escrow account, which is to be handed over to the seller, who is the assessee, on the completion of the transaction. The purpose of this escrow account was that if any liability arises because of the sale of the shares, then that amount will be paid from this escrow account. The case of the assessee was completed under section 143 subsection 3 scrutiny, and when the scrutiny assessment was done, after that some liability was there because of the sale of shares, and this liability was paid from the escrow account, due to which the assessee was not able to receive the full consideration from the escrow account. Now the apprehension of the assessee was that my assessment has been done, I have not received the full consideration, so my computation of income should be revised, my income should be recalculated. The assessee was having the option of going into the normal appellate proceedings, that is, the assessee can go into the CIT appeal also, and the assessee has also the option of going to the Principal Commissioner of Income Tax under section 264. The assessee opted the path of section 264 and prayed before the Principal Commissioner of Income Tax that my sale consideration should be revised, and accordingly the refund should be granted to me. The apprehension of the principal CIT was that I cannot give you the refund and I cannot reduce your income below the returned income. This was one of his main apprehension, that I cannot reduce your income below the returned income under section 264. And the second point was that he was saying that the capital gain is calculated by reducing the transfer expenses from the sale consideration. So the liability which was paid was not the transfer expenses. So I cannot deduct that transfer expenses. But the point of the assessee was that these are not transfer expenses. Assessee was saying that I have received less consideration, so it was not a part of the sale consideration. So it is not a transfer expenses, but it is a less consideration which has been received by me. But Principal CIT was not impressed and he passed the order against the assessee. That's why the assessee went to the Bombay High Court, and Bombay High Court said that there is no bar on the power of the Principal Commissioner of Income Tax under section 264 in going below the returned income of the assessee, and it should be reduced from the sale consideration, because the real income theory says that in actually assessee has not received this sale consideration, so this income has not accrued to the assessee. When this income has not been accrued to the assessee or has not been received by the assessee, you cannot take the tax from the assessee. And if the tax has been taken from the assessee, then it is the duty of the department to give refund to the assessee on that increased income, which has been given by mistake or which has been given because of the procedural integrities of the Income Tax Act. But if the tax has been collected and the assessment has been done, so it doesn't mean that if any tax has not been collected without the authority of the law, according to Article 265 of the Constitution of India, then you have to give this refund to the assessee. Friends, I think that this case is a very welcome judgment, and it gives a ray of hope to the income tax assessee is that if any tax has been paid which was not legally leviable on him, so assessee in those cases can even go to the Principal Commissioner of Income Tax against the order of the AO to get it refund. Friends, this is a very good judgment. Everyone should read the full judgment, and this matter has been reported in 445 ITR at page number 110, and this is the very, very intelligent judgment of the Honorable Bombay High Court. Thank you, friends.